right, anything further?
No, Your Honor.
No, Judge.
Okay, well, this is a difficult case, there's no doubt. We're all glad it didn't go to trial, honestly. Certainly the conduct here is extreme, and I believe it should be met with extreme punishment. I don't think there's any doubt about that. I'm never going to understand how one human can cause serious harm to another. I'm never going to be able to understand that. The pain and harm that you've caused for this victim is going to never be gone from her. She's got serious and long-lasting consequences from what happened here. And we may never know what was going on in your head or what caused you to do these things, but what I am going to do is follow the recommendations of the attorneys and impose a sentence, whereas you will not be out and able to make these types of decisions again for quite a while. I'm going to start by reviewing the violent offender form, which I'm going to give you to sign after I've reviewed it. So, you have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in Ohio Revised Code 2903.41. If you're not you are sentenced, hold on. Since you're sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after your release from prison. If you are an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of residing in or occupying a dwelling in Ohio for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide the sheriff certain information, including your full name and any alias you use, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card number issued to you, information regarding the offense of which you were convicted or pled guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle, and a description of each vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that is changed, and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of the above requirements for a period of 10 years. Since your expected release residence address is in Summit County, you shall enroll in person no later than 10 days after release with that county sheriff's office at 205 East Crozier. Failure to enroll or failure to verify residence at the specified times will result in criminal prosecution. I'm going to have you sign this acknowledging that this has been explained to you, that you understand the requirements, and that you must abide by all of these provisions of the Ohio Revised Code. All right, we're going to get you a copy of that before you leave today. So when I am making a decision as to sentencing, I have to review the seriousness and the recidivism factors set forth in the revised code 2929.12. Clearly, and when we look at the seriousness factors, the victim suffered serious physical, psychological harm. And when I look at the recidivism factors, at the time that this happened, you were under post-release control for an earlier offense. You had a history of criminal convictions. You were out on a warrant at the time, and despite prior attempts to rehabilitate you, you engaged in the same behavior that you'd previously engaged in. And so I will find that both the seriousness and the recidivism factors weigh in favor of a prison sentence in this case, which I think is no surprise to anyone. Based on all the facts and circumstances and consideration of those relevant sentencing factors, considering the statement of the victim and the victim's family, the state, the defense, your statement, applying the minimum sanction, I'm determining will protect the public and punish you without imposing any unnecessary burden on state and local resources. And again, analyzing all the factors I'm required to analyze, I am going to impose the following sentence. So on counts, I will find that counts 1, 2, and 5 do merge for sentencing purposes. And on those counts, on count 1, I will impose a sentence of 11 to 16 and a half years under the Reagan-Tokes law, and I will review that with you again in a minute. Because that is going to be the longest sentence that I impose, that will be the one that will carry the Reagan-Tokes tail. On counts 3, 4, 6, 7, and 8, all felonious assault counts, I am going to find that at least 2 of those are separate offenses. When I look at the TBI that was suffered and the injuries to her eyes, clearly there was enough of an impact to cause that type of injury. And then we've got the testimony of going to hurt your other eye. We've got the videos demonstrating that, and all those factors. I would consider any head injuries to be one serious physical harm, which would warrant a separate sentencing for purposes of everything. And then also we have the use of a bat, which is a deadly weapon, and then also we have the fractures in her hand and the bruises all over her body. I mean, I just don't see how bruises can be developed in different stages if they didn't happen in different stages, and that was what I was told today, is that the bruises were in different stages of development. So I'm going to impose a sentence of 5 years on count 3 and 5 years on count 4. On count 10, and counts, and I guess I should be more specific. On count 6, 7, and 8, I'm going to impose 4 years. I'm going to state that those 3 counts can be sentenced separately, but those will run concurrent with each other, but consecutive to counts 3 and 4, which will be consecutive. So we have 11 and 16 and a half plus another 10. The strangulation is a separate offense. I don't know how anybody could possibly, the legislature went to the bother of creating a strangulation offense because of the fact that we have this activity occurring in our society right now where people think it's okay to strangle somebody. For that offense, I'm going to impose 2 years, and I'm going to impose 2 years for the escape. So that comes out to 25 to 31 and a half years. I am going to run counts 1, 2, and 5. Obviously, we said that merges. Consecutive with counts 3, consecutive with counts 4, concurrent with 6, 7, and 8, and consecutive with 10. And then the escape on the other case is consecutive by law. I will find consecutive sentences are required by statute because, first of all, for the 2 count cases, because the escape must run consecutive, but also in the kidnapping case, I believe consecutive sentences are necessary to protect the public and to punish you, and they're not disproportionate to the seriousness of your conduct and to the danger that you pose to the public. And both of these offenses were committed while you were out on post-release control, and your history of criminal conduct demonstrates consecutive terms are necessary to protect the public. I will note, as you know, you're not allowed to use drugs or alcohol while you're in prison. You may be tested for that. We calculated your jail time credit on our break. There's 394 days of jail time credit will be added to your journal entry. That starts today, or ends today. So anything after today, ODRC will calculate for you. So if you go back and you want to check it, we calculate as of the end of today. I told you upon completion of your prison sentence and upon release from prison, for the felony 1, you will be supervised on post-release control for a mandatory minimum 2 years up to a maximum of 5 years as part of your sentence as determined by the parole board. There are, on the other charges, there are lesser offense or lesser sentences for PRC, but because we have the highest level offense, that is the one that will be imposed by them. And I did tell you what would happen if you violated post-release control. Do I need to review again what would happen, or did you understand?
No, ma'am.
All right, I also need to, on the record, talk to you about the Reagan Tokes, the 11 to 16 and a half. As I indicated, we take the 11, we cut it in half, and we add it to the end, and that's how you get the tail. I reviewed with you earlier today that it is possible to earn good time credit of 5 to 15% against your sentence. Would you like me to review with you again how you do that, or are you satisfied with what you've been told today?
I'd like for you to review it with me.
Okay, so if ODRC recommends a reduction, it is presumed that you will be released at the presumed early release date. They would notify the court. If I don't agree, I would notify the state and the victim, and we would have a hearing. And at that hearing, I would have to find that the presumption was overcome in order to not agree to that. The factors I would look at to see if that presumption was overcome: did you violate rules that compromise prison security or safety of staff or inmates, cause harm to staff or inmates, or violate the law while you were in prison, and those infractions indicated that you had not been rehabilitated, or if your behavior while incarcerated demonstrated continued threat to society, or if you were still security level 3 or higher, or if you did not productively participate in a majority of rehabilitative programs that were recommended, or complete a reasonable number of programs that you started, or if you did not have a fixed residence address upon your release. Any of those reasons would cause me to pause, potentially find that the presumption for early release was overcome, and then you would serve your regular sentence, that was whatever the sentence was imposed. Alternatively, when we get to the 25 years, there's another 6.5 years there that ODRC could keep you if they chose, and they also have standard they need to follow. Once you get to the 25, I no longer have any control over that. At that point in time, they would be looking at, did you violate rules that compromise prison security or safety of staff or inmates, or cause physical harm to staff or inmates, or violate the law while you're in prison? Did that indicate you had not been rehabilitated and demonstrate that you continued to pose a threat to society? That would be one prong for them. So it is a higher standard for them. If you were in extended restricted housing anytime the year prior to your release, so that's, you got to kind of be in trouble to be in extended restrictive housing. If anytime that year prior, they could say they're not going to release you. And then again, if you were still security level 3 or higher, those are reasons that they could say they weren't going to release you. They would set a new date for you to be reviewed, and then at that time they would go through that whole thing again. They could not hold you longer than the 30.5 years. Okay? All right, and then finally, you do have the right to appeal the conviction, or actually the sentence in this case. You do that by filing a notice of appeal with the clerk of courts of the Court of Common Pleas within 30 days of the sentence. If you're unable to pay the costs of the appeal, you have the right to appeal without payment of those costs. If you're unable to pay counsel for the appeal, the court will appoint counsel without cost. If you're unable to pay for the cost of documents necessary for the appeal, those documents will be provided without cost. You have the right to a notice of appeal time